Welcome back, everyone, to another episode of the Canadian Immigration Podcast. And this is a vlogcast episode as well, because this will be available on our Canadian Immigration Institute YouTube channel. I've got a special guest today, LJ Dangzalan. How are you doing, my friend?
I'm doing good, especially after walking on the beach yesterday, which explains the sick tan. I just realized it when I saw myself on the camera.
That is awesome. So I am recording here from my fine home office in Lethbridge, Alberta. But where are you, LJ?
I'm in the Philippines, specifically in the lovely island of Boracay.
Nice. Very cool. Well, the location is very fitting for the topic that we're going to be discussing today. And it is probably one of the most confusing aspects of immigration, especially if you're involved in the world of business immigration, the recruitment of overseas personnel, the whole temporary foreign worker program, and all of those things. Um, I think we have a lot of experience with it. Most immigration lawyers that practice business immigration law, until it comes to the stage where our companies say, hey, we want to recruit from the Philippines. They are some of the best, foreign workers that we can have for our businesses. And then they say, what's this exit visa thing? So as we start off here, Lou, I want to, I'm just going to pull up this. The very first topic that we want to cover is the whole concept of all of this. And it starts with the Department of Migrant Workers, so the DMW. So what is this entity? What are its jurisdiction and powers?
So it's a very recent addition to the family of departments in the Philippines in the executive branch. And the Department of Migrant Workers has jurisdiction over Filipinos working abroad. But if we wind the clock a little bit back, I'd say about 5 decades, really. So not that not that little, in
Yeah,
fact.
yeah.
It takes its origins from the 1970s institution called the Philippine Overseas Employment Agency, which a lot of our colleagues at the bar would be familiar with the
That's what I was.
POEA.
That's what I was going to ask. Where did it go? The POEA. Where did it go? And so,
So it got subsumed under the Department of Migrant Workers. They're still in the same building. And what happened was, just like all the other attached agencies related to foreign Filipino workers working abroad, they've been housed under a single department and they turned it into a cabinet portfolio, a proper department on its own right.
interesting. All right.
Yeah.
Okay, so that's a good starting point. Okay. Next thing we want to talk about is this whole, concept of a overseas Filipino worker. And it's interesting, these acronyms that we're so familiar with. So OFW was something that was new to me. And over the last
Hmm.
little stretch, when I first started practice, I worked with a ton of Filipino workers. And
Hmm.
I think it would have been just prior to the launch of Express Entry in 2014. In fact, Alberta was filled predominantly with amazing Filipino workers through the LMIA
Right.
process, the Temporary Foreign Worker Program. And then there was these rumblings that this new program was coming. And all of these workers who were eligible into the Canadian Experience class, their lives were going to change. And so when I remember I was on a working group with the Canadian Bar Association, and it was on Express Entry, we looked at those initial regs, and we offered we drafted a submission and we sent it off to the government. And after reading it, I immediately went and wrote a blog post for my website. And it was entitled, I think, the top 5 things you need to do now to prepare for Express Entry. And really, it was directed to the Filipino workers to a large extent. And within half a day, my website crashed. And I talked to my
Oh my.
provider and I was like, what's going on? So, well, it crashed because you had too much, there
Wow.
was too much traffic on your website. And it wasn't like, today there's a whole lot more bandwidth. But back then, I think I was up to about 15 or 16,000 people that came to the site that day, and it just wasn't equipped for it. So we boosted it up, opened the bandwidth up, and the next day it crashed again. And it was all
Whoa.
just trying to give advice and direction to people on what was coming. But the problem, Lou, was that there wasn't a whole lot they could do about it. They were kind of locked in. And to a large extent, those that were international students on postgrad work permits,
Hmm.
they didn't have the LMIA, which at the time gave them 600 points. So people don't remember
That's
that
right.
when Express Entry was launched, an LMIA guaranteed an ITA. Not so today
Pretty
at
much. Yeah.
all. And
Hmm.
so I had days where I did 10 consults with Philippine workers, and 90% of them ended up with me, singing an old Roy Rogers song, which was Happy Trails. And there was not much that could be done. They were locked in, the time had been spent, and with the shifting rules, they just weren't going to be able to qualify, to get an ITA, even though they were fully qualified for CEC. So considering now we've flashed forward to today, almost 10 years, I guess we're 9 years from that. There's a lot of workers in Canada asking themselves the same thing right now. And so
I
when
was
you're
going to say
talking about,
deja vu.
yeah, it is. It is. So tell me about this concept of an overseas Filipino worker, which is very rare in the world of international mobility. Like, I don't know too many other countries that have this. Maybe you can give a little bit of background on it.
So yeah, so it really evolved from this very explicit policy of the Philippine state to send its workers abroad. This takes its origins from the 1970s when there was the oil price spikes, when basically countries were dealing with their current account deficits. So the Philippines, what it did was to boost its dollar reserves, to send its
Mm,
workers abroad to essentially earn those dollars, and they know that they were going to send them back to the Philippines, and they were originally called overseas contract workers, and that was a
okay.
temporary thing until today. It truly is still temporary. The lion's share of Filipinos who are abroad are actually in the Middle East, working in countries such as Saudi Arabia,
Yep.
the UAE.
UAE.
Outside the
Mm-hmm.
Middle East, the biggest Filipino representation would be in the US, followed very closely by Canada. So when I moved to Canada, there were only about 300,000 Filipinos in Canada, but now I think we're reaching about 1 million. So
Yeah.
it's a pretty strong representation, uh, and considering that the U.S. has about this roughly the same proportion in terms of like population size, it's pretty interesting. So OFWs essentially was just a an agglomeration of like Filipinos who are abroad, who are working on contracts, but there is a legal definition. So that's kind of like a politically and socially accepted terminology, but there is also a legal definition. So under the statute that created the Department of Migrant Workers, an OFW is now defined to be someone who is um, not on their way to permanent residency, who is not on their way to citizenship in another country, but are working in another country temporarily, or who
Ah,
are basically working on contract on a short term or even an indefinite contract, say for example if they're abroad. So it does cover a lot of folks. Statisticians have put like about 10% of the Philippines population to be abroad at any given point. So
wow.
it's a country of about 120 million. So
That's
that's about
amazing.
12 million Filipinos abroad. So not everyone in that 12 million umbrella would be considered OFWs. For example, those who are already permanent residents or citizens, because I think the Philippines is the only Southeast Asian country that allows for dual citizenship. So we do hang on to those.
Yeah.
And OFWs are basically now agglomerated together. And since it's a legal definition, they are under the jurisdiction of the Department of Migrant Workers. And the context there, the short of that, Mark, is that the state takes interest into the welfare of its citizens abroad. The Bright Line test case that I remember was in 2003, I believe it was. There was a Filipino worker who was kidnapped in Iraq, and the Philippines was part of the former President George W. Bush's coalition of the willing, and he was specifically the Filipino worker was specifically targeted because they were part of the coalition of the willing, and since then. Philippine foreign policy has always been geared towards taking care of its citizens abroad. So this is why there's like this specific interest and intent to actually like look into this. And most people find that the requirements of the DMW to be cumbersome,
Yep.
employers included and immigration lawyers in Canada included. But there is a particular reason why they exist.
That makes sense. Okay. Now you'd mentioned that part of the definition of an OFW is that they are not otherwise on a path to permanent residence or citizenship. So, who
Right.
makes that determination? Is it a self-declared status? How is it, established? Because I think
Hmm.
For the most part, when a Filipino worker comes to Canada, I think a fairly large portion of them are interested in potentially pursuing permanent residence. So, do they just make that as a declaration, or is there something they have to provide as proof or evidence of that, or they have to be, in the process of submitting an application, or how does that work?
So that's where the ambiguity comes from, Mark. And we have to consider that Canada, along with Australia and New Zealand, really, the Commonwealth countries, where you have a tendency to convert your temporary residence into permanent residence, we're the exception. Uh, as opposed to, say, for example, the majority of Filipinos working in Middle Eastern countries where they're forever on a temporary visa.
Mm-hmm.
And once they're done with their
Yep.
contract, they return home, right? So there's not really a lot of thought put into it until recently, especially since there was this massive growth of Filipinos leaving the Philippines for Canada, specifically on international student status, and of course their spouses would come with them on C-42 work permits. And that's
Mm-hmm.
interesting because that created this nebulous category. And one thing I should note is that while the DMW exercises jurisdiction over OFWs, enforcement's actually a different department, just like in Canada.
Mm-hmm.
It's the Bureau of Immigration, which is under the Department of Justice, and they have basically the enforcement arm. And one other thing that probably our fellow members in the bar should basically take note is that just like in Europe, the Philippines also has exit immigration kiosks. Just like when you're exiting through an airport, for example, you have to clear immigration first,
Yep.
and that's where you interact with the Bureau of Immigration as a Filipino citizen leaving for work. And a lot of the enforcement was a bit nebulous because they haven't really figured out the category, and this is why I sent you that advisory
Mm-hmm.
along with other lawyers as well, because it's so important, because now that they've turned their mind to it, there's finally a bit more clarity. And I think, in my opinion, while it sounds like they're adding requirements, it actually clears up a lot of things that would prevent misery at the border, because there's a lot of stories where workers who have their tickets booked, they're ready, they've quit their jobs, they're moving on to a different country, are offloaded from their flights because they haven't met a specific requirement. So now they're actually making the rules very clear, and I think that's a good thing.
Yeah, I think so as well. Yeah, I think so as well. And I'm just going to just pull it up here for our
Hmm.
fine viewers. And I think this, you can see this okay. So this
Yeah,
is the advisory, and we'll get to this one. This is kind of later down the list, but this is what you had sent. And
right.
so yeah, we'll chat a little bit about that. Okay, let's shift to our next topic. So, if not considered an overseas Filipino worker, does the DMW exercise any jurisdiction? So how does that play? Like, how far is the reach of the DMW?
Hmm. So basically, like, a person who is not in Canada, for example, as a temporary foreign worker, say for example, they're on an A-75 exempt work permit, meaning they're on a bridging open work permit. It's an open work permit that allows them to work for any employer. So it's not contract specific, because say for example, they've applied for permanent residence. This is really what allows them to apply for this open work permit, right? So now the DMW has like said that in those situations, they will not exercise jurisdiction because they're on the path to permanent residency.
Yep.
But what's curious about the advisory, and I know that we're going to get into it later, is that it also classifies post graduation work permits as being within the ambit of their jurisdiction, even if it's an open work permit.
Right.
So it's very, tenuous at best. I would say how they've like, come up with these, decisions. I think it has to do with the fact that a lot of international students are actually in Canada, from the Philippines, that is, and there's a lot of exit, and a lot of the requirements are not clear. And what's happening is that the Bureau of Immigration is enforcing it selectively, not to their fault. I think it's because of the lack of policy direction. So this really sets it out that, say, for example, if you're a PGWP holder, that you need to comply with the requirements and that you are under the jurisdiction of the Department of Migrant Workers. But that's in opposition to someone who's on a bridging open work permit. They don't need to satisfy the requirements of that particular department. So it really boils down to that advisory, Mark, and further monitoring of the advisories coming from the department is actually quite necessary, in my opinion, because these things tend to change, especially if Canada changes its categories for like LMIA exemption. It would make sense that the Department of Migrant Workers would actually follow suit in adjusting its own policies as well.
Yeah, I agree. So you mentioned a lot about these requirements. So let's talk about them, because I think this is also one of
Hmm.
the things that most of us immigration lawyers, at least in Canada, are not fully clear what this is all about. We know there's something that needs to
Right.
happen in terms of exit, and if they fit within the, you know, the the definition of an overseas foreign worker, at least now I understand that
Hmm.
concept, that there's some expectations of these individuals, and I know we'll get to that as well. But so what is the Philippines and the the DMW? What did they actually require from these from the
Hmm.
workers when they're working abroad? I'm assuming, and I've always understood there was a portion of their wage or that needed to be paid, and as you
Hmm.
indicated in the early days, it was designed to help, right? When you're sending your
Hmm.
workers abroad to to help with the GDP of the country, essentially, and
Hmm.
overseas workers and the export of labor, which the Philippines is a phenomenal country for that. And I guess to a large extent, it's almost become a part of the resource that the country has to offer is its people. So requirements for overseas Filipino workers when they're working abroad. Can you talk a little bit about
So
that?
for sure, and we're talking about OFWs, strictly speaking, at this point. Generally, and I think this dovetails perfectly into the next section of this discussion, and I'd like to discuss them both together. Um, Essentially, there is a ban against direct hiring by foreign, I mean non-Philippines based employers of Filipino citizens who are working abroad. It's actually entrenched in the Philippines Labor Code
Heavy yet.
under
I'm
Article
I'm on top of
18.
this, my friend. You bet. We've got it here.
Thank you. And yeah, as you can see in front of you, foreign employers can't actually be recruited directly unless they're exempted from it. And this article, I should say,
Mhm.
also spells out the special circumstances where you're allowed to hire directly. So those would be members of the diplomatic corps, for example. International organizations are exempt. Anything that deals with recruitment by heads of states and government officials. Other employees may also be allowed by the department, essentially, those who are deemed by the department that are allowed who are skilled. So, essentially, how you want to think about this is you want to classify your workers as skilled or semi or low skilled, right? So, if it's semi or low skilled, at all times, they cannot be hired directly. You have to go through an employment agency authorized by formerly the POEA and now the
Mhm.
Department of Migrant Workers. Um, but if you're dealing with professional or skilled workers, yes, you can go through a recruiter in the Philippines that's accredited by the Department of Migrant Workers. But in special circumstances that are determined by the department, you can get an exemption. And in the past, I've helped employers in Canada deal with this. They have to liaise with the Philippines Overseas Labor Office, which has also been renamed, Mark. So I'm sure you're
Okay.
familiar with
Yep.
POLO.
Mhm.
Now they're called
Indeed.
the Migrant Workers Office.
Okay.
And they're
That
still
simplifies it.
attached to the Philippines consulate. And, there are offices in Canada. Toronto's the bigger one. And then you also have Vancouver. I believe Calgary also has one. Um, and the short of this is that if professionals or skilled workers are coming to, say, Canada, for example, and they're hired directly by a Canadian employer, the Canadian employer can seek an exemption from the ban on direct hiring by meeting the requirements set by the Migrant Workers Office. So they should liaise with the MWO that's in charge of their jurisdiction. So out west, it's usually either Vancouver or Calgary, If not, out east and central, it's usually the Toronto office. And you should phone them. You can also email them, and they're pretty responsive, in my opinion. They're quite nice over at those offices, and they'll give you a checklist of their specific requirements. Here's a practice tip, a practice hack, Mark. So we have a tendency because we're so thankful to our friends over at IRCC and CBSA that they actually list out the requirements for a lot of things for most programs out there, right? With the migrant workers office, they may have a checklist available on their websites, but most of the time I find it's still best to actually check with the office and talk to a human person
Mm.
as to what the requirements are, the current requirements, because they may have added something and they may have not gotten around to updating the website. They do handle a lot of files, so I understand there are limited resources why they haven't done so. But for the most part, they're generally the same. But there are nuances that they have to that you must capture. And I think getting to this checklist is very important early on. Just like as immigration lawyers, you and I, Mark, when we advise our clients, don't come to us at the last minute. Don't come to us 2 months before your permit is about to expire. Come to us when ideally before you even get here, for example. So I would say the same thing for employers. Try to get that checklist, try to get help first before attempting this, because there are certain requirements that the MWO would impose on you. And this one, the most notorious one, I would say, is the contract addendum. So the MWO would ask an employer to actually amend an already sealed contract between employer and employee, already approved under the LMIA that you worked so hard on, to add a contractual change between the employer and the employee that guarantees certain things that are generally covered by each province's Employment Standards Act. But you have to understand, like, Canada's an advanced democracy,
Yeah,
so
and
a
this
lot of these
applies to every country around the world, so they're trying to safeguard. I get it. Yeah.
that's right. They're creating that baseline because that is their mandate to protect Filipinos working abroad. So you got to understand where they're coming from, and you got to understand and make MW understand when you're dealing with them that, listen, our employer is aware of that, and in fact, yes, we already have those provisions that you want into the baked into the contract way ahead. But generally speaking, they're very much like I wouldn't say obsessed, but they really want to have their form addendum clauses signed. So I would generally advise my employer clients to actually just accede to similar, very similar language as an annex to their normal contract, and have language vetted by an employment lawyer in Canada of your relevant jurisdiction, so that nothing is contradictory, so that it
Yeah.
will not create any problems, for example, moving forward with whatever provincial law that you're dealing with. So those are things that, as an immigration lawyer in Canada, you can help your client with when liaising with the migrant worker office, for example. But again, like, it really is key to get your checklist right from the get-go, because they do change, and a lot of times the one that they post on the website may not be the most up to date.
Interesting. Okay, let's roll back just a little bit. You mentioned the distinction between skilled and low skilled. So is that similar to our national occupational classification system? Like, if we have a
Yes.
familiarity with that, is it pretty similar? I'm assuming that there's going to be some exceptions, but is there like a knock in the Philippines that helps to determine, the occupation you're trying to fill and how they're classified?
Well, I'm not aware if the Philippines actually uses a classification similar. I would imagine that there exists one. But here's some good news for our fellow immigration practitioners, Mark. The migrant worker office actually relies on ESDC's list anyway. So if you're looking at the tier levels, it makes it simpler for us, right? So anything below tier three would be
Three.
considered semi-skilled
Yep.
and low skilled, right? But anything tier three and up would be considered skilled. So it's
Okay.
as simple as that. They used to refer to the NOC zero A's, B's, and C's and D's,
Mhm.
but of course they had to adjust their language. And when ESDC made that announcement, of course MWO, or Polo at the time,
Adjusted.
followed
Yep.
suit.
Uh-huh. Okay. I've been dying to ask this question. All right. So you've got these requirements, and I'd like to dive just a little bit deeper into them per se. But, and maybe I'm putting the cart ahead of the horse, but what actual teeth does the organization have to enforce when
Right,
it's outside of their domestic jurisdiction? So I'm
right.
assuming that they say, well, fine, employer, if we've got reports that you're not playing ball, we're going to ban you from, you know, hiring any future employees, right? I'm assuming that those bans, but like what types of enforcement mechanisms do they have, and how do they protect the workers?
Well, similarly to what uh, Service Canada would have, they do have a blacklist of employers as well that have not complied with their requirements, for example. And what's interesting is the Department of Migrant Workers also calls out recruiters and even immigration lawyers and consultants from other jurisdictions and they put it out in advisories that so and so consultancy or law firm did
Nice.
not comply, and
Yeah.
it's quite interesting that they're very vocal about this, and these are some of the enforcement mechanisms. Because as you know, like obviously, like enforcement is territorial, but this
Yeah.
is kind of like a weird space where everyone is like flying in between jurisdictions. Everyone's kind of like in a gray zone. So there are enforcement mechanisms that they've found suitable for this. For
Do they have
example,
amps? Do they have amps in the same way that like the administrative monetary penalties?
they cannot obviously penalize a Canadian
Yeah.
employer
Yeah. But if they've got
because
it,
they
but
are
if they
not
have a
within.
presence, but if they have a presence in the Philippines, is there a mechanism in place to then lay a fine or some form of monetary penalty to
Potentially,
organizations that
there are
are
penalties, but the biggest penalty would be the ban from
banned
further
from the yeah
hiring.
yeah
Yeah. So, and if your presence relies on the services provided by its citizens, then
yeah
it's a big blow to the company, right? The other thing is on an enforcement note, from the perspective of the Filipino worker being deployed to Canada, for example, they can prevent you from traveling.
ah
Remember, unlike Canada, the
yes
Philippines has immigration exit clearances. Like you have to go through an immigration queue, just like in Europe. So before you actually board your flight, you have to clear not just the TSA or CATSA equivalent here in the Philippines, but also through immigration. And if you can't clear immigration, you can't board your flight. And even I've heard of situations where even in situations where you've boarded your flight, they can still recall you from the flight and offload you if
hmm,
they've realized that you've not complied or your employer has not complied. So those are
interesting.
enforcement mechanisms. But once they're in a foreign jurisdiction, it becomes very problematic. I've heard of stories where an employer is non-compliant, deemed to be in Canada, and what the Polo back then, or what the MW is now, had done is to send notice to the Canadian employer that they're not in compliance. There's no enforcement mechanism in reality, but they can still send a letter to an employer that, hey, you're
Mhm.
not in compliance. And essentially, what that does is in the future, you won't be able to hire from the Philippines. So if you're
Okay.
thinking of an AMP equivalent in Canada, they
Yeah.
obviously can't do that. I
Yeah.
think Global Affairs Canada would not be
Yeah.
very happy with a foreign jurisdiction doing that.
Yeah. Yeah. Okay, so let's take this one step further. We've already
Hmm.
discussed the fact that there are many Filipinos in the Middle East working.
Hmm.
So if they are not physically in the Philippines at the time in which they enter into whatever type of employment agreement with a Canadian company, then are they outside of the purview, the jurisdiction, or how does that work?
That's a very good question. And in fact, a lot of folks use this loophole. I'm going to call it a loophole at this point because it is what it is. Let's call a spade a spade. That if you're not in the Philippines, the Philippine government loses its enforcement mechanisms. As I said, one of the things that they can do is that they can make your departure as a Filipino working
Uh,
overseas very difficult, but it still doesn't prevent them from, say, for example, banning the company from essentially recruiting from the Philippines. But here's the conundrum that I think you probably are thinking of
I
right
know where
now.
we're going with
But
this. Yeah.
yeah, the company is probably not known to the Philippine government at that point to have directly hired from a Filipino citizen who was residing in Dubai, for example, who is now going to work a tech job in Toronto. So at that point, does the Philippine government know? Of course not. Like the Philippine government does not have exit requirements from Dubai going to Canada, except in a weird situation. So here's where the rubber hits the road. So if that OFW or a TFW in our case in Canada
Mm-hmm.
um, decides to go back to the Philippines for a quick family getaway, say for
Uh-huh.
example they have a family reunion in the
A
lovely island of
wedding or
Boracay,
something. Yes.
exactly, they may have problems leaving
Huh.
the Philippines.
Okay. Okay. So on that note, then, and by no means am I offering strategies to get around this, but someone who decides to go for a vacation in Dubai, and so they're leaving the Philippines, and really in their luggage they've got the contracts and everything already signed up with the
Hmm.
offer of employment with a Canadian company, and so they're taking a little trip to Dubai. If that came to the attention, I'm assuming, of a border, whatever, the exit officers, the exit control officer in the Philippines, um, they would then have the jurisdiction to say, hey, wait a minute, this looks
Right.
like you're trying to do an end run around this. And so I'm going to block you from boarding your flight. And I think there
Hmm.
was some discussion about that in the past, and whether or not officers sometimes will go overboard and almost almost see things that maybe are not there, just when they
Right.
see certain patterns, and if you fall into that pattern, I'm not going to say it's profiling, but really it may be. And so I'm assuming they've got tremendous powers to
Yeah.
to on the exit of the citizens of the Philippines.
Let me titillate your imagination a little bit more, Mark. I mean, you were a former border officer, you're a
Mm-hmm.
former BSO. So the immigration officers, the IOs, are deputized by the Bureau of Immigration in the Philippines with
Yeah.
similar latitude as
Okay.
BSOs.
Yep.
So they have a lot of discretion and they have
Detention,
broad
whatever they need.
sweeping powers.
Yeah.
Exactly, in order to
Search,
enforce
seizure.
whichever acts. Exactly.
Huh,
So,
okay.
in that situation, if they are carrying those contracts, they could be in trouble if the officer kind of like figures out that you don't pass the sniff test. And in fact,
Yes.
I'd go further. So, at the institutional level, the Philippines has gone further by partnering with certain jurisdictions where they've known that a lot of Filipinos are trying
Ah,
to circumvent the
okay.
enforcement by basically not deputizing foreign jurisdictions, but alerting them that this is something that some Filipinos are doing. Case in point, in Hong Kong. So Hong Kong is a 2-hour flight from Manila. It's a very popular destination. Filipinos are visa exempt from entering
Ah,
Hong Kong.
okay.
And what they typically had done in the past is that they would book a trip to Hong Kong, maybe even book a trip to Disneyland before heading on over
Nice.
to Canada, right?
Mhm,
So
mhm.
they'd go to Disney Hong Kong and enjoy Hong Kong for a couple of days, maybe do some shopping and have some nice chow mein, and then fly on to Canada and not return to the Philippines.
Ah,
So yeah, that would circumvent it. Except now, Hong Kong immigration officers are now live to this because there's a government to government cooperation,
mhm.
so to
Yep.
speak, to prevent
Not
this kind of
unlike
activity from
Canada's
happening.
cooperation with our partners, right? The
That's
US,
right.
Australia,
Yeah.
New Zealand, UK. I can see the similarities. Mhm. The question
So
is,
yeah,
who
so
thought of it first? You know?
yeah, it's a good question. Yeah. So yeah, so there are ways that people are circumventing, but of course the government of the Philippines is adapting. And it's quite interesting because even if you do manage to get away with that, we go back to that same problem. What if you have a wedding to attend in Boracay, in the
Yeah.
Philippines? Your exit is going to be hell. If you haven't,
Ah,
sorted the requirements at that point, because it is possible they don't stop you from like getting directly hired if you're living in Dubai, then you move to Toronto, and if you go back to the Philippines for the wedding, make sure that your employer is also complied with the requirements. Now, you want to do that is when you get to Toronto, your employer should be liaising with the migrant worker office in their jurisdiction, in that case, the Toronto MWO. And then you should basically comply, your employer should comply with it. So you'll have the necessary paperwork so that when you go and visit the Philippines to attend the wedding, you have your OEC, which is the Overseas overseas employment certificate. It's essentially an exit visa, which I believe is the next point under your
It
slide
is.
there. So
Yep.
yes, so what is an OEC? Simple terms, it's an exit visa for foreign workers, for OFWs. It's a certificate that basically says that you've gone through the Department of Migrant Workers process, that they vetted your contract if you're a direct hire, or if you were hired by an employment or a recruitment agency, that you went through the proper channels and that you've paid your insurance, et cetera, et cetera. So the interesting thing about OECs is that, you know, it used to be a manual process, in-person process, but in the world of online transactions, they've since completed the transition of this application to an online portal. So it's actually pretty accessible. And if you go to DMW's website, in my opinion, it's a bit of a cluttered website, but if you look hard enough, you'll find things, and you'll find really interesting things, including the portal that allows you to apply for an OEC in order to get your paperwork in order. So thankfully, they've proactively done this. And what's interesting is I think it was a recent development. There used to be a fee for this, but the president of the Philippines actually directed the department to remove the fees because
Mm.
there were a lot of OFWs complaining. It's a minimal fee. It's really 100 pesos, which is
Yep.
25 cents, I think, Canadian. Oh no,
Mhm.
sorry. $2.50. Yeah, there you go. So it's not a very big expense, but it is still cumbersome because you have to figure out a payment method. And I'm not sure if they accept Visa or MasterCard
Mm.
for this type of payment. I think you have to go to a bank. So if you're vacationing in the Philippines, you have to like
Yeah.
queue at the bank, et cetera, et cetera.
It's a pain.
It's annoying. So I get why they wanted to get rid of it. It's a minimal fee. It doesn't even. I don't think it's even cost recovery at this point.
Hmm.
But yeah, they got rid of the fee, so that's good news at least.
Indeed, it is. All right. So we've now come to the part that really kickstarted all of this, and that's the recent advisory on open work permit holders from Canada being captured by this. And
Right,
for as long as I can remember, this this regime was triggered in the context of a temporary foreign worker program application, an LMIA
right.
based work permit. All right, so this is actually a good segue now to what all of this was leading up to, which is this recent advisory that you had shared with me on open work permit holders from Canada now potentially being caught within the regime. And for years, Lou, I have always understood that this whole regime has been restricted to LMIA based work permits within the temporary foreign worker program. And so I think a number of people are going to be very surprised to see
Hmm.
this new advisory. And so let's just pull it up here and let's expand it so we can see it a little bit more. So talk a little bit about this here, this new advisory.
Right. So it's an advisory number 9, series of 2024. So I know that there have been 8 other advisories so far this year. And what this does is it lays out the ground rules for, a subset of workers heading for Canada. And as you said, you're absolutely right. Typically and instinctively, immigration lawyers in Canada in the know would think that the restrictions set by the POEA back then, or now the DMW, would refer to international or Filipino workers who are being deployed under LMIA or work employer-specific work permits. Not anymore, it turns out, because there's been an outgrowth, a massive growth of Filipinos heading for Canada or holding open work permits as a result of the expansion of the international student program to the countries, including the Philippines. And as you know, C-42 open work permits for spouses and common law partners of international students do come to Canada on open work permits. And what this document does, Mark, I think do need to give credit to the Department of Migrant Workers for their work by outlining and essentially setting the rules of the game in very clear terms, so that there is no ambiguity in terms of enforcement. Because in the past, before this advisory came out, um, essentially those who are holding open work permits or are leaving the Philippines, returning to Canada, for example, are nervous, essentially, because they could face an immigration officer who may not necessarily appreciate like what an open work permit or what type of open work permit they're holding when they're going to Canada. For example, if you're the spouse of a Canadian citizen who is sponsoring you under the family class, then would you be covered by this directive? The short answer is, and on page 2, it says no. If you're
Yep.
on the way to permanent residence, you're actually exempt from the OEC requirements. But interestingly, now, if you are holding a post graduation work permit, which is also an open work permit, it's not specific to an employer, they've now put you within the ambit of enforcement of the Department of Migrant Workers. And it's interesting, if you go to page 1 at clause 2, uh, subclause B, it says that those who are holding a bridging open work permit and post graduation work permit at B2 basically are required to submit to OEC requirements and are now, for the purposes of the department, classified as OFWs. So in
Mm.
the past, they were in the gray zone. PGWP holders were, okay, we're not really OFWs because we were not specifically hired by a company abroad or by a
Right.
recruitment agency. And rather, I am holding on to this work permit because I studied in Canada. And
Yes.
as a former international student to Singapore, Mark, I can tell you that, the exit requirements are pretty weird as a Filipino citizen going to Singapore because there are specific exit requirements for OFWs, but I was not classified as an OFW because I wasn't working in Singapore, even if I had the ability to, take on part-time employment in Singapore under limited circumstances. And it's quite interesting because, you know, um, PGWP holders have kind of like taken advantage of that particular gray zone for some time, but not anymore. So now they have to comply. But the good news here is that, they're protected, their rights are enforced, and at the same time, the application process has become less and less cumbersome so long as you come prepared. And this is why it goes back to that point I made earlier, and the point that you always make in your podcasts, Mark, that uh, you know, don't wait until the last minute to consult an immigration lawyer when it comes to getting advice on how to do these things, because the best solution is always prevention, right?
Yep.
Just like with doctors, they do the same thing. They say the same thing to their patients.
Yes. One thing, like from a practical standpoint, let's play this out for a post grad work permit holder. So they travel to Canada, obtain their study permit, they graduate, they apply inside Canada for their post grad work permit. At what point in time is this triggered? So, and
Hmm.
how practically does it play out? Is it only a situation where they are traveling back to see family for a vacation? They've talked their employer into giving them a month off of unpaid leave, which happens, and then they
Right.
go back to see family. Is that when it's triggered, or do they have a proactive obligation at the time in which they actually apply for their post grad work permit to then, contact
Right.
uh, the make contact to initiate the process?
Right. I suspect that we can get two answers here. One is, if you ask the migrant worker office,
Hmm.
they'll probably say that you need to be proactive, or they may not, but from their
Yeah.
perspective, from an institutional perspective, they prefer that you're proactive about this. But really, there's no legal requirement for you to report to the MWO in Canada. You're under Canadian jurisdiction, you're following all the
Yeah.
rules in Canada, so on and so forth. But of course, if you go back to the Philippines for a family visit or a vacation, and as we discussed earlier, that's when the enforcement mechanisms come into play, right? So the ideal is, obviously, before you leave for the Philippines, you need to make sure that your paperwork is in order.
Yes.
So contact the MWO, figure out what the requirements are so that you can liaise with your employer so that you can get your paperwork in order so that even before leaving for the Philippines, you have your paperwork ready upon exit. It'll save you a lot of misery and cost, for example. Um, the other thing is, it's also a gray zone, Mark. So let me give you another scenario, which is interesting because you raised case of a PGWP who's just taking a vacation, a paid vacation from their employer. What if they just finished their program and they still have not secured employment, right? And they're holding on to a post graduation work permit. They decide to go back to the Philippines, maybe for a 2 3 months break because they've had enough of studying.
Yeah.
Um, before looking for employment, and they say, oh, you know what, I'll look for a job while I'm in the Philippines, right? And that's, funny enough, like, you don't find an employer, and then you're going back to Canada, you're holding on to a PGWP, and yet you don't have an employer. So how then do you comply with the OEC requirements,
Right.
right?
Yeah.
So you're again stuck in the gray zone. So this is why you should probably seek legal help before doing these things. It's very tricky, because if you get to a reasonable immigration officer, they'll understand your circumstances. But what if you don't? It's always the luck of the draw sometimes with an officer, unfortunately. And generally speaking, they're very nice. They're very understanding as long as your paperwork's in order. And what I've noticed that as immigration officers, and I suspect you're a former BSO, you really appreciate it when the people coming to you are already prepared and they have their files in order, right? Because it's facilitative. They feel the same way.
Yeah. It's interesting you mentioned that because, and we spoke about this before we started this podcast episode, the fact that we're receiving so many consultations now from people who are just wondering what the future holds and are there permanent resident options available for them and what do they do? And, in some instances, people will make the wrong decision and maybe work
Right.
without authorization. And it never ceases to amaze me how many employers in Canada are actually willing to hire someone under the table. I thought we were a much more compliant country than than for example the US. I thought that it would be hard for people to work under the table, but that's not the case. So we have some individuals, and I have consults with them where there may have been a period, especially during the pandemic or shortly after, where work permits were expiring. In the midst of
Hmm.
that whole 18-month post grad policy, when they were re-upping these extensions for people, and people are faced with, what do I do? I have this period of unauthorized work, and I just had a consult just before we went live, or recording this, where the spouse received a letter from IRCC when they were going through their pay slips and pay stubs through the one of the caregiver programs, and now they have to respond to it because there was a 6 week
Hmm.
period where where she was working without authorization, and it was a
Hmm.
gap, and it was a gap, Lou, between where a work permit application had been refused and the 18-month magical fix all came about, where voila, you can now work by edict of I don't know what, an email, a letter. I
Hmm.
don't even, it's so hard with even the authority for those things,
Yeah.
but it happened. And then you've got officers questioning, well, looks like you've been working for a lot longer than just 6 weeks without authorization, but for months and months. Well, no, wait a minute. Your own
Hmm.
department said that this was, there was a curative provision within it. But anyways, so we're dealing with this. And as an officer, when I had someone who, and this is how I advise my clients, disclose, take responsibility, and beg for
Exactly.
forgiveness, right? and
That's
and
right.
and officers, I found that they are far more willing to show leniency and discretion when someone is owning the problem. They're
Hmm.
disclosing it. It's not a situation where someone has to dig for it and discover it and find it out and then
Right.
ask. So it's great. It's a great advice. And no matter whether you're leaving the Philippines or whether you're entering Canada, humans are humans, and they tend to be
Absolutely.
kinder to people that that are trying to make their life easier. So awesome.
Absolutely. Yeah. So, yeah, again, like, just to circle back on the point about like advice, it's very important to get that advice before actually, like, getting that wheel to turn, before getting that rubber to hit the road, because you don't know what the effects are, especially in situations where the rules are a bit gray. So, what this administrative advisory does is it clarifies the rules of the game for a lot of folks. But as I just pointed out, PGWP holders are covered by this advisory, but yet there can be circumstances where it can be unclear. So how the heck are you going to comply with the OEC requirements if you don't have an employer?
Right.
The whole point of an OEC is to essentially get your employment contract reviewed. And here's another
Mhm.
thing, Mark, as a lawyer, you and I would advise employer clients of ours to have everything documented. I used to work in the employment law space, and on the employer side, obviously, I would
Yep.
advise get everything documented,
Yeah.
get everything, properly written out in a right employment contract that is up to date with statute,
You
regulations, and
bet.
common law.
Yeah. Yeah.
And interestingly, there's still a lot of Canadian companies that hire without
Oral.
a written contract.
Yep. Oral contracts. Yeah.
Absolutely. That doesn't mean that you don't have a contract.
Mm.
So that's when you actually need to talk to folks like Mark and myself to
Mhm.
actually sort it out with your employer. So before you even leave Canada, you have something to report under the OEC regime.
Yeah. Yeah. Very, very interesting. Yeah, this whole world, and like you said, this advisory, and we'll put a link to it in the show notes, just so that people know where to go. But this does have some pretty interesting ramifications now when you're employing Filipino workers in Canada. It's not just LMIAs, as you can see here, and they lays out the different categories. I love the fact, Lou, how they actually reference the exact confirmation code, so there's no confusion about the types of
Absolutely.
work permits that are being covered in here. They're very
Yeah.
clearly laid out. C90, 72, 50 even. It's amazing that they're identifying it.
And to me, it says something about the Department of Migrant Workers. Actually, they're a recently created department, but they clearly know what they're doing, and they're really wizened up to Canada's immigration system, which I will say, tip of the hat for them, like
Yep.
being ahead of the game and trying to unsow confusion, because there was quite a bit of confusion
Yeah,
in terms of enforcement, especially as like the cohort of Filipinos leaving for Canada increases over time.
indeed. Well, this is great. This has been super, super helpful. Those of you who are wondering, how do I contact Lou? Well, in the description for the podcast episode and the video on YouTube, you'll be able to get access to Lou's contact. And this is his website. You can just simply book a consult, super easy. And there you go. All right. Well, thank you so much, Lou. It was great having you here. And thanks for the insight on this area that can be probably, well, it's definitely an area of a considerable grayness in our practices. And when you've so astutely pointed out that just because you've read the website doesn't necessarily mean that that's the most current, policies of the department. It makes sense to use someone that knows what they're doing, and all of the advice you've provided here has been excellent. So thank you so much, my friend. We'll definitely have to have you back again as we see this new directive actually be applied.
Well, it's always a pleasure. Thank you for the invitation, Mark, and I'll see you in the next.
You bet. Take care.